See, today's the 20th.
Yes, sir.
All right, this is case number 23 CR 227, State of Ohio versus Kevin D. Treadway. Are you Kevin D. Treadway?
Yeah.
All right, this is an arraignment. Mr. Treadway was indicted by the grand jury on December the 5th for felonious assault, a second-degree felony. State's represented by Assistant Prosecuting Attorney King. And Mr. King, has the alleged victim of the offense been notified of the time, place, and purpose of this hearing?
Yes, he has, Your Honor. He's elected not to appear.
All right. All right, Mr. Treadway, you were indicted with felonious assault, as I said, which alleges in the indictment, the sole count of the indictment, that on or about October 13, 2023 in this county, you did knowingly cause serious physical harm to which is the identifier for the alleged victim, in violation of section 2903.11A1 of the Ohio Revised Code. So that's a second-degree felony, which if convicted carries a possible prison term of between 2 and 8 years as a minimum set by the judge, with the possibility of that being expanded to up to 1/2 of the term imposed by the court at the determination of the Department of Rehabilitation Corrections. So that means that that could extend to up to a maximum of 12 years. There's also a possible fine of $15,000. Now, you are entitled to have an attorney to represent you. And if you do not have the funds to hire one, the court will appoint one for you. And I see you have filled out a financial disclosure form. Is everything on this correct?
Yes, sir.
You live alone?
No.
Who do you live with?
My girlfriend, my fiance,
Okay.
Kim Sweet.
Pardon me?
Kim Sweet.
Okay.
Right here.
All right.
I was
So you're receiving workers' comp, is it?
No, I draw Social Security.
I'm sorry?
I draw Social Security.
Social Security, okay, all right, SSD, all right. The court then will determine that you are entitled to appointed counsel. Let's see. Where's the chart on that, Ben? I thought I had it.
That's it.
Pardon me?
I didn't have it sitting there.
Oh, here it is. Underneath here, all right, thank you. Okay, the court will appoint Attorney Catherine Hapner of Hillsborough, Ohio, to represent you. In the absence of counsel, I'll enter a not guilty plea on your behalf. All right, we'll set your first pretrial for January the 17th. That'll be at 2:00 p.m. Set your final pretrial for February the 21st at 2:00 p.m. Trial date will be set for March the 11th. I'll make it March 14th, I'm sorry, March 14th at 8 a.m. Let's see, now, did you post bond when you were,
Yeah.
they let you out, was it an OR bond only?
Your Honor, this was a direct indictment.
Oh, this is a direct indictment, okay. So you were summoned, all right. So your bond will be an OR only, which is your promise to appear. And if you fail to appear, then you could be prosecuted for an additional felony, and if convicted, sentenced on that no matter what happens in this case. There's a deposit that is required to secure payment of certain statutory required fees, $171. You can make payment arrangements with that with the clerk. So you'll also be under pretrial supervision of the probation department during the pendency of this action. And that's located at 117 East Main Street. Do you know where that is, across from Flagway Station? Report there immediately after court. And you're to report to them once a week for 4 weeks. After that, as they determine, you undergo random drug testing they may order, provide phone numbers for home, cell, and employer if become employed. Not to have any kind of contact with the alleged victim, directly or indirectly, through third parties. No email, social media, no contact whatsoever. You're to be evaluated. If recommended by probation, you'll submit to an evaluation for substance abuse or mental health issues, and if any treatments recommended, then you will enroll in and follow that during the pendency of this action. Now, you'll also be under house arrest at your residence, and that is 140 North Fairfield Street. All right. So that means you have to be there at all times unless you're working, going to and from work. You can go to and from any kind of medical appointments.
I wonder if I can get a physical therapy.
Well, just let me finish, okay?
Okay, thank you.
All right. Don't interrupt me again.
Sorry.
Now, you can go to and from work. You can go into and from medical appointments. So that includes any therapy, appointments with doctors, hospitals, blood work, anything that was related to a medical treatment you can go to. You can go to any kind of court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You can also go to any church services, and you can go to family holiday events. You have to go to and from those exceptions directly. You must notify the probation department in advance of your plan so that they'll know where you are. If you fail to comply with these conditions, Mr. Treadway, then the court could order you to be held in custody until determined what appropriate bond would assure your compliance with these conditions and your appearance before the court. Now, have you been to the sheriff's office to be fingerprinted and photographed?
Yeah.
Okay, all right. So, you're going to go around the bar here and sign on this. Wait a minute, let me finish.
Oh,
okay.
I'm sorry.
And sign your assignment notice, and that's going to give you your court times and dates. And do you have access to a smartphone or a computer with a camera so to do video conferencing? If you do, we can do this by Zoom for at least the pretrial, first pretrial. So if you have an email and a cell phone number, give that to the court assistant over here.
Okay.
Now, you're going to go downstairs then, after you sign that, down to the clerk's office and sign your OR bond, make payment arrangements for your deposit. Then you're to go down to the probation department directly and report to them to tell them you're on pretrial supervision.
Okay.
All right, do you have any questions? All right, now you can step around.
Thank you.
Good morning, Your Honor.
Good morning. Have a seat there. All right, this is case number 23 CR 204, State of Ohio versus Ryan O'Neill Coleman. And you're Ryan O'Neill Coleman?
Yes, Your Honor.
All right, and you've entered your appearance counsel?
I've entered on behalf of Mr. Coleman, who's a defendant.
All right, thank you. Assistant Prosecuting Attorney Adam King is present for the state. The defendant was indicted by the grand jury on the 5th of December on 2 counts of compelling prostitution, 1 count of disseminating matter harmful to juveniles, attempting corrupting another with drugs, and trafficking of marijuana. Mr. King has the alleged victim or victims of the indictment, counsel in the indictment, been notified of the time, place, and purpose of this hearing?
Yes, Your Honor, and they have elected not to
All right. All right, now, Mr. Bennett, has your client had a copy of the indictment for more than 24 hours?
Yes, he has.
Do you wish to have the indictment read?
Yes, sir. I'm sorry, Your Honor.
Do you wish to have the indictment read?
Waive recitation of the indictment, Your Honor.
All right, and what is your client's plea?
Not guilty.
All right. All right, you have your calendar there, Mr. Bennett?
I do.
All right. Looking at let's see, was this a direct indictment, or has there been a bind over on this?
Fine, no, Your Honor.
All right, but been on bail. Okay, how about, well, what about March 11th?
It's the entire month of March.
Oh, it's the entire month of
Yeah,
March.
yeah.
Oh, okay, all right. Is that a capital case?
It is.
All right.
Yeah.
April the 8th?
That's fine.
Okay. Okay, and that would be at 8 a.m. All right. State wish to be heard on the matter of bond.
No, Your Honor, as I indicated earlier, the defendant's already posted a bond in county court. The state has no problem with that bond being carried over applying to this case.
All right. Oh, here it is. $50,000.
Yes, Your Honor.
Okay, from Universal Fire Raging Cajun. Okay. That bond will be continued. Plus an OR, you'll need to sign an OR as well, Mr. Coleman. An OR bond is own recognizance. That means that you promise to appear as required. You're going to get an assignment notice here in a couple minutes. If you fail to appear, you would be subject to being prosecuted for an additional felony, and if convicted, sentenced on that no matter what happens in this case. There's a deposit required of $116. Making payment arrangements for that within 30 days to the clerk. That's to secure the payment of certain statutorily required fees. You'll be under pretrial supervision of the probation department at 117 East Main Street. Are you already under supervision there? All right. Well, you'll report there immediately after court, and that is just down the street here across from the Flagway station block east of here, or half a block. You'll be required to report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing they may order, provide phone numbers for home, cell, and employer, not to have contact with any of the alleged victims in the as set forth in the indictment in any way, directly or indirectly, by email, social media, through third persons, no contact whatsoever. If recommended by probation, you'll be evaluated for substance abuse or mental health issues, and if there's treatment indicated, then you'll enroll in and follow that treatment during the pendency of this action. You'll be under house arrest at your residence, and you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings, in this and any other case, attend any kind of court hearings in this or any other case, appointments with an attorney in this or any other case. You can also attend any kind of job training, schooling, educational programming, etc. Go to church services, and you can also go to any family holiday events. You have to go directly to and from those events and exceptions. And if you violate any of those conditions, then the court could have you taken into custody until further determination of the appropriate bond to ensure your compliance and your appearance. What is your address, Mr. Coleman?
237 McLean Avenue, Greenfield, Ohio.
All right. So that'll be the address that you're to be at. And you're to communicate with the probation department whenever you're going to be going to and from any of those exceptions to the order. All right. Is there anything further from counsel?
No, Your Honor.
Nothing, Your Honor.
All right. Then, Mr. Coleman, you're going to come around here and get assignment notice. Gives you your dates and times. Go to the down to the clerk's office, sign your OR bond, and make payment arrangements on the deposit, and then report down the street to the probation department. Thank you. All right, are you Lamont Rickman?
Yes, sir.
All right, this is case number 23 CR 205, State of Ohio versus Lamont Rickman. Mr. Rickman, you were indicted by the grand jury on the 5th of December along with Trinity Rickman in an joint indictment. You were indicted in the first 4 counts, 1 count of trafficking in cocaine, possession of cocaine, trafficking in drugs, and possession of drugs. Count 1 alleges that on or about October 10, 23 in this county, you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution or distribute cocaine, a Schedule II controlled substance amount equal to or exceeding 5 grams, less than 10 grams when the offender you knew or had reasonable cause to believe it was intended for sale or resale by yourself or another. And that is a violation of Section 2925-03A2, and that is a 4th-degree felony. Count 2 alleges on or about the same date you possessed that. That's a 4th-degree felony as well. Count 3 alleges on or about the same date in the same county you knowingly prepared for shipment, shipped, transported, delivered, prepared for distribution or distributed buprenorphine or naloxone sublingual film, 8 milligrams, 2 milligrams, / 2 milligram, Schedule III controlled substance, again, knowing or having reasonable cause to believe it was intended for sale or resale by yourself or another. That is a 5th-degree felony, and count 4 alleges you possess those, and that is a 1st-degree misdemeanor. So the 2 4th-degree felonies carry a possible prison term, if convicted, of between 6 and 18 months, and a fine of $5,000. And the 3rd count, the 5th-degree felony, carries a possible prison term between 6 and 12 months, fine of $2,500. And the 4th count is a misdemeanor of the 1st degree, which is 6 months in county jail and a $1,000 fine. Counts 1 through 3 also carry a possible prison term, a possible license suspension of 6 months to 5 years. Okay, now you're entitled to have an attorney, Mr. Rickman, to represent you in this matter. And if you cannot afford to hire one, then the court will appoint one for you. And I believe you filled out your financial disclosure form, and everything on this is correct?
Yes, sir.
All right. And it looks like in the lower court, Mr. Armentrout was your attorney?
Yes, yes, sir.
All right. Okay, the court then appoints Mr. Armentrout to represent you. And in the absence of counsel, I'll enter a not guilty plea on your behalf. We will set your first pretrial for January 17th. That can be by Zoom. Do you have a smartphone or access to a video computer?
Yes, sir.
All right, we'll give your email and telephone number to the bailiff when you sign your assignment notice, and we can do that by Zoom so you don't have to travel here for that. We'll do that at 2:30 p.m. on January 17th. Final pretrial will be January 31st at 2:30 p.m. and can also be by Zoom. And then the trial date will be set for February the 29th at 8 a.m. and have to be in person. Now, let's see. Like you were bound over from the municipal court or county court. Did you post a bond or were you on your OR?
OR.
OR only? Yes, okay. All right, so your OR, own recognizance, is your promise to appear. You're going to sign that down in the clerk's office. If you fail to appear, you could be prosecuted for an additional felony, and if convicted, sentenced on that no matter what happens in this case. You'll be under pretrial supervision of the probation department. Well, I'm sorry, let me back up. You'll have to pay a deposit of $171 within 30 days and make payment arrangements for that with the clerk. Now, you'll be under pretrial supervision of the probation department at 117 East Main Street in Hillsborough. You know where that's located? All right, you report there as soon as you sign your OR bond downstairs. You'll be required to report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing they may order, provide phone numbers for home, cell, and employer. Is this Trinity, is that your daughter? All right. Does she live with you?
Yes, sir.
All right. If recommended by probation, you're to be evaluated for substance abuse or mental health issues, and any treatments indicated. You enroll in and follow that during the pendency of this action. You'll be under house arrest at your residence. That's 613 Nelson.
Linden Avenue.
Or Linden, I'm sorry. Linden Avenue in Greenfield. Now, it means you have to be there unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You can go to any kind of job training, educational programming, anything of that nature. You can also attend church services and family holiday events. And it's just you and your daughter that live there?
Yes, sir.
All right, you can also do personal business such as going to the grocery store, bank, stuff like that, but other than that, you can't go, you cannot go to and from other places. You'll contact the probation department to let them know in advance, and when you talk with them, they'll explain to you how you're to let them know about that. Because if you violate any of these conditions, including violating your house arrest, then the court could revoke that bond and have you held till further order the court to determine what would be appropriate bond for you to comply with the court's order. All right, so you're going to step around here in a moment and sign your get your assignment notice and give them your phone number and your email address. Then you're also going to go downstairs to sign your OR bond and make payment arrangements on that deposit. And then from there, you're to go to the probation department. You have any questions?
No, sir.
All right, thank you.
Thank you.
All right. This is case number 23CR206, State of Ohio versus Trinity R. Rickman. Are you Trinity R. Rickman?
Yes, sir.
It looks like Trinity Rand Rickman. All right. Ms. Rickman, you were indicted along with Lamont Rickman on the 5th of December by the grand jury. In this case, it's one charge for you. It's possession of a fentanyl-related compound and it alleges that that offense occurred on or about, it's in count 5, on or about October 10, 2023. In this county, you did knowingly obtain, possess, or use Schedule 2 controlled substance with fentanyl-related compound. So that's a violation of Section 2925.11 of the Ohio Revised Code. Now, that, if convicted, carries a possible term of incarceration of 6 to 12 months and a fine of $2,500, and a possible license suspension of 6 months to 5 years. Now, you are entitled to have an attorney to represent you in this matter, and if you don't have the funds to hire one, the court will appoint one for you. And I see you did fill out the financial disclosure form. Everything on this is correct?
Yes.
All right. And Mr. Wagner was your attorney in the lower court? All right. So the court will enter a not guilty plea on your behalf, appoint Mr. Wagner to represent you. Your first pretrial will be set for January the 17th at 2:30 p.m., and that can be by Zoom. If you give them your address and phone number and email. January the 31st at 2:30 p.m. will be your final pretrial. Trial date will be set for February the 29th at 8 a.m. And you were released under OR as well, right?
Yes, sir.
Okay. So you'll be allowed to continue to be on your OR, which is your promise to appear. And if you fail to appear, then you could be prosecuted for an additional felony, and if convicted, sentenced on that no matter what happens in this case. You'll be under pretrial supervision of probation department at 117 East Main Street in Hillsborough. You know where that's located?
Yes.
All right, you report to them immediately after you complete paperwork at the clerk's office. You'll be required to report to them once a week for 4 weeks. After that, as they determine, undergo random drug testing in my order, provide phone numbers for home, cell, and employer. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. If any treatment is indicated, you enroll in and follow that during the pendency of this action. And you'll be under house arrest at your residence at 613 Linden in Greenfield, meaning you have to be there at all times. And except if you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You can also attend any kind of schooling, job training, educational programming, attend church services and family holiday events, and also personal business like grocery shopping and that type of thing, banking. But you have to go directly to and from those locations directly, and keep the probation department informed of when you'll be going and where, so they can monitor that. If you violate any of these conditions, the court can have you taken into custody and held until further order of the court to determine what the appropriate bond would be. You have any questions? All right. You're going to step around here and sign your assignment notice with your dates and times. Give them your phone number and email. You're going to go downstairs to the clerk's office to sign your OR, make payment arrangements on your deposit, and then go directly down to probation. All right? Thank you. All right, Stephen Willet. All right, are you Stephen Michael Willet?
Yes, sir.
Okay, this is case number 23 CR 224, State of Ohio. You trying to put your glasses away? Okay, go ahead. All right, case number 23 CR 224, State of Ohio versus Stephen Michael Willet. Mr. Willet is present. Mr. Willet, you were indicted by the grand jury on the 5th of December on 3 counts. Count 1 is illegal conveyance of drugs of abuse onto the grounds of a specified governmental facility. Alleges that on or about July 14, 2023 in this county, you knowingly conveyed or attempted to convey onto the grounds of a detention facility, the Greenfield Jail, or of an institution, well, that's not, doesn't apply, a drug of abuse, as defined in statute, which is fentanyl-related compound, in violation of 2921.36A2 of the Revised Code. So that is a third-degree felony, which if convicted carries a potential prison term between 9 and 36 months and a fine of $10,000 and a possible license suspension of 6 months to 5 years. Count 2 alleges on or about the same date and time and place you knowingly possessed a fentanyl-related compound. That is a fifth-degree felony, which carries a possible prison term between 6 and 12 months, a fine of $2,500, and a license suspension of 6 months to 5 years. Count 3 alleges on or about August 25, 2023 in this county, you knowingly obtained, possessed, or used methamphetamine in amount equal to or exceeding bulk amount, but less than 5 times bulk amount, in violation of section 2925.11. So that's aggravated possession of methamphetamine, which is a third-degree felony with the same penalties in count 1. Now, you are entitled to have an attorney, Mr. Willet, to represent you. And if you cannot afford to hire one, the court will appoint one for you. And I see you have filled out a financial disclosure form. You don't have any, you have your income as 0. Have you been working, or are you receiving any kind of benefits?
Just a little walking in jobs.
All right. And you don't show that you live with anyone, and so obviously you got to be living with someone, or you wouldn't have it.
I've been staying with a friend.
With a friend? Is that 417 Boyd?
Yes.
Okay. All right. Court then will find that you are entitled to appointed counsel. Now, is this the first time you've been in court on this case, Mr. Willet?
Yes, sir.
Okay. Court will appoint Attorney Dennis Kirk of Hillsborough, Ohio, to represent you. I believe he's around the courthouse here somewhere. He was a gentleman you saw over here a minute ago. He has a hearing coming up here in a minute. And in the absence of counsel, I'll enter a plea of not guilty on your behalf. We'll set your first pretrial for January the 17th. Do you have a smartphone or a computer, access to a computer with a video camera?
Yeah.
All right. Will you give your email and phone number to the bailiff here after we're done when you sign your papers? We can do the pre-trials by Zoom, so you don't have to drive over here for that, as long as you can get online. If you can't, then you have to come in person. So your first pre-trial will be set for the 17th at 2:15 p.m. That's of January. Final pre-trial will be set for February the 21st at 2:15 p.m. And we can do that by Zoom as well. Your trial date will be set for March 11, and that'll be in person, of course, and that's at 8 a.m. Yeah, and that'll be here. Now, you were summoned on this indictment, I believe. You were just served with your paperwork by the sheriff?
No, I came over and turned myself in.
Okay, well, you came and picked up your paperwork.
Paid a bond.
Oh, you did pay a bond? All right, let me look and see what that was. Wait a minute. Okay, this is what we call a direct indictment. So you were picked up on a different charge, apparently. Is that? But you were served with this. You just picked up your paperwork on this. Well, actually, I don't even. Have you got a copy of this indictment?
Yeah, I came over and picked it up.
Oh, here it is, December the 7th. Okay. Yeah, you were summoned. They didn't ask for you to be arrested, so you don't have to post a bond. If you've got a bond, that's on a different case.
Well, see, Your Honor, I got bonded out in these cases here, and I used Cajun Raisin, and there was a sum, right?
Yeah.
Can I get my money back from them?
I don't know. You'll have to talk to your attorney about that. I think maybe what happened is the charge was dismissed because they had to wait on lab results, and they must have presented this to the director. I'm just guessing. I don't know. I don't know what goes on in these cases until they come in front of me. But in any event, in this case, you were summoned. So your bond is an OR only, which is your promise to appear. And that means that if you fail to appear, you could be prosecuted for an additional felony. And if convicted, sentenced on that no matter what happens in this case. Now, there will be a deposit of $171 to cover certain statutory required fees, and you need to pay that within 30 days. You'll make payment arrangements downstairs with the clerk to do that. Now, you're going to be under pretrial supervision of the probation department at 117 East Main Street, and you know where that's located, around here across from the Flagway. You report there immediately after court. You are to report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing. They may order, provide phone numbers for home, son, employer. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. If any treatment is recommended, then you'll enroll in and follow that during the pendency of this action. You'll be under house arrest at your residence, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You can also attend any kind of job training, educational programming, schooling, GED, college classes, etc. You can attend church services, and you can also attend family holiday events. You must go directly to and from those places, and you must keep the probation department informed in advance. If you fail to comply with these conditions, and also if you change your residence, if you have to go somewhere else, you need to let them know where that is, because they need to know where you are at all times. Again, if you don't comply with these orders, then the court could have you taken into custody and held until further order regarding the appropriate bond in your case. Do you have any questions, Mr. Willet?
Yes, Your Honor. The summons almost like a subpoena.
Yeah, it's an order for you to come before the court in a criminal case. In a criminal case, you have to come to court if you're summoned instead of arrested. So you've done what you were supposed to do.
Okay. Say like, I showed up today.
I'm sorry?
I went over to post a bond, what it did and stuff, but I still got those orders maybe.
You have an OR in this case. Whatever happened in the other cases, I don't know anything about that. That's nothing I have any involvement in. I'm only concerned with this particular case. Anything else that's happened, you'd have to talk to an attorney about that. All right? Thank you. So come around. All right, this is case number 23 CR 225, State of Ohio versus Deanna Everhart. You're Deanna Everhart? All right, Ms. Everhart, you were indicted by the grand jury on December 5th. Looks like 6-count indictment, 3 counts of theft of drugs, and 3 counts of illegal processing of drug documents. Count 1 alleges that on or about July 1, 2022 through January 31, 23 in this county, you did with purpose to deprive the owner identified as V1, that stands for victim 1, alleged victim 1, of property, knowingly obtained exerted control over that property, hydrocodone pills, which is a Schedule II controlled substance. Count 2 alleges on about the same period in the same place, you did the same thing to a different alleged victim, V2, otherwise it's the same thing, hydrocodone pills. Count 3 alleges on or about the same date and time, same place. You did the same thing with regard to a different person alleged to be identified as B3. Each of those offenses carry a possible prison term if convicted of between 6 and 18 months, a fine of $5,000, and a fine of $5,000. Now, count 4 is illegal processing of drug documents, and it alleges on or about same date, time, July 1 through January 31 of, well, let me back up, July 1 of 2022 through January 31 of 23 in this county. You knowingly made a false statement in a prescription order, report, or record required by statute, and it was a Schedule II controlled substance, hydrocodone. Count 5 alleges the same thing, and count 6 alleges the same thing. I'm guessing that related to 3 different persons as set forth in counts 1 through 3. Each of those are fourth-degree felonies as well, the same penalties that I described earlier. Now, you're entitled to have an attorney to represent you in this matter, Ms. Hargett. If you cannot afford to hire one, the court will appoint one for you. Now, I see that you have filled out a financial disclosure form. You're listing monthly employment of $3,120. Is that from VA disability?
No, that's my husband's VA.
Oh, that's your husband's VA?
Yeah.
Okay, you have it listed under applicant.
I'm sorry.
Okay, so then is your income the $7,000 or?
No, my income actually ends today because I'm under contract with Amazon for seasonal work.
Oh, okay.
So my contract ends today.
So you'll be unemployed then after today?
Yes.
Will you be drawing unemployment?
If I can.
All right.
As far, I have not drawn unemployment, and from what I've been told, they go back 6 months, and 6 months ago I wasn't working, so.
All right. Well, then you are entitled to appointed counsel. Now, have you been in court on this already?
No.
Is this the first time?
Yes.
All right. Court-appointed attorney Danielle Witt of Hillsborough, Ohio, to represent you. In the absence of counsel, I'll enter a not guilty plea on your behalf. Now, do you have a smartphone or a computer with a camera that you can do video conferencing? All right. You'll give those email and phone number to the bailiff or court assistant immediately following the hearing. And then we can do those by Zoom, so you won't have to come here. If you don't have access to it, then your hearing will be in person. We'll set your first pre-trial for January 31st, and that'll be at 2:30, and that can be by Zoom. Final pretrial will be set for February 21st, also at 2:30 by Zoom. Trial date will be March 11, and that'll be at 8 a.m. in person here at the courthouse. And you were just issued a summons and you picked that up at the sheriff's office?
They delivered it to my house.
They brought it to your house? Okay. When did you get that?
Not this past Friday, the Friday before.
All right. 'Cause
Well, I don't know if it has the date on it.
okay. Well, we don't have a return. Would you make a note to the clerk to contact the sheriff? We don't have the return of the indictment in the file. All right. So you are released on your own recognizance only, and excuse me, that's your promise to appear. And if you're going to get a date or a paper with your date, time, and everything on it. If you fail to appear, then that would subject you to being prosecuted for an additional felony, and if convicted, sentenced on that, no matter what happens in this case. You'll be required to pay a deposit to cover certain statutorily required fees of $171 within 30 days. You'll make payment arrangements at the clerk's office when you sign your OR bond. Excuse me. Now, you're going to be under pretrial supervision of the probation department, 117 East Main Street. You know where that's located? Just down the street across from, on the other side of the Main Street, across from the flagway station on the alley. You report there immediately after court, or after you get done at the clerk's office, I should say. Then you'll be required to report to them once a week for 4 weeks, and after that, as they determine, to go random drug testing they may order, provide phone numbers for home, cell, and employer, have no contact with any of the alleged victims, directly or indirectly. You cannot do anything in terms of email, letters, posting on social media, no contact whatsoever. If recommended by probation, you'll be evaluated for substance abuse or mental health issues, and any treatments indicated, you're to enroll in and follow that during the pendency of this action. You'll also be under house arrest at your residence, meaning you have to be there at all times unless you're working, going to and from work. That can include looking for employment. You can go to and from any kind of medical appointments, court proceedings in this or any other case. You can go to and from appointments with an attorney or probation officer in this or any other case. Attend any kind of job, training, educational programming, any kind of college classes, GED, etc., church services, and you can attend family holiday events. You must go directly to and from those places, and you must keep the probation department informed of that in advance, and they'll explain to you how that works when you report down there today. Now, did you go to the sheriff's office to be fingerprinted and photographed? All right, well then you'll need to report after you go to the probation department for your pre-trial supervision. You report to the sheriff to be fingerprinted and photographed, etc., for booking. All right, we will notify your attorney of her appointment. You can get her phone number from the clerk's office and contact her to see her. So after you get done, you're going to sign your assignment notice. Here, I'll give them your phone number and email. Go directly downstairs to the clerk to sign your bond and make payment arrangements on your deposit. Then down to probation, and then on your way out of town, stop at the Justice Center out behind college and at the sheriff's office where they'll process you. Have any questions? All right, thank you. All right, that's everybody for All right, this is case number 23 CR 176, State of Ohio versus Kevin Stewart. Present representing the State of Ohio is Assistant Prosecutor Adam King. Representing the defendant is Attorney Dennis Kirk. You are Kevin Stewart?
Yes, Your Honor.
All right, Mr. Stewart has entered a plea of guilty to one charge of permitting drug abuse, count 43, a fifth-degree felony. The court referred the matter to the probation department for a pre-trial or for a pre-sentence report. I have received that and reviewed that. I've also referred the case to the drug court docket. Mr. Stewart did meet with the coordinator, and she has filed a letter indicating that he would meet the clinical criteria, and I believe he has also filed an application for admittance into the program. All right. Mr. King, anything on behalf of the state?
Only was contained in the plea agreement, Your Honor.
Mr. Kirk?
Thank you, Your Honor. With escort follow the plea agreement, my client's been compliant with pretrial supervision. He's currently enrolled in the treatment program at Reaching Greenfield and has met with the probation department and the treatment coordinator in regards to drug court. He does have a few barriers. Transportation's been an issue, but I did speak with Ms. Sturgill about that. She advised they can assist with that. So would ask the court to follow the plea agreement.
All right, Mr. Stewart, anything you would like to say?
No, Your Honor.
All right, well, Mr. Stewart, you met with the drug court coordinator, and I know she went over things with you. And the way the drug court works, Mr. Stewart, is I don't order people into that program. People have to apply to be admitted into it because you have to want to do this. You know, regular community control or probation has the goal of keeping a person out of prison. And so we have certain requirements, and you know, so long as you comply enough with those to not be required to be revoked, you can stay out of prison. Now, that does include, requiring you to get any treatment you might need, but the approach is different because, again, the whole purpose of that is for you to stay out of prison. And the drug court is different. The drug court focus is on helping somebody deal with their substance abuse problem and to become sober, and to stay sober, and to rebuild their life. And I've known you for a long time. I don't know how many years, but as long as I can remember being a prosecutor. And you've had had issues in your life, and the program is designed for people like that. It's not designed for a first offender. It's designed for somebody who's been in and out of the system and has been in and out of treatment and so forth. But it all comes down to you wanting to be in the program, because I'll just be honest with you, it's harder than regular community control because there's more involved. Now, I do know you have some transportation issues, but we do have FRS now, and they have regular transport for people. We have a lot of folks from Greenfield area in the program. And it can also help you with working to try to get your license. We've had people with seeming like impossible challenges to get their license back in the program who have. We've had, I think one guy had like 17 different suspensions, and he eventually got his license back and graduated from the program. So this gives you a chance to change your life and to lead the rest of your life in a law-abiding manner, because your record's clear that but for your history of substance abuse, you most likely probably wouldn't know each other, and so this is giving you that chance. So is this what you want to do?
Yes, it is, Your Honor.
Okay. Well, the court then is accepting you into the program, Mr. Stewart, into the drug court docket, and it's ordered that you be put under community control in that program under these conditions. First of all, you have the program description. I know you signed it, and they gave you a copy. You're going to be required to comply with all those conditions. That's what the conditions are. But I'm going to highlight certain ones just for the record. First of all, it'll be for a period of 3 years. It could be extended up to 5, but it's a 3-year, up to 3-year program. Average graduation is about 22 to 24 months. It's a minimum of 18 months. You'll be required during that period to obey all laws and to conduct yourself in a law-abiding manner. Report when and as directed. Be truthful in statements you make to the probation department. You keep them informed of your residence, place of employment at all times. May not change either without prior permission. Do not leave the state of Ohio at any time without prior written permission. You're not permitted to enter upon the grounds of any correctional facility or to communicate with or visit anyone who's an inmate in those facilities without prior written permission. You're not permitted under either federal or state law to possess, have, or use or purchase any firearm, ammunition, or dangerous ordnance, because to do so would be a criminal offense under both federal and state law. It's also a condition you not do that while you're under community control in this case, or any other weapons of any other type. You're not permitted to purchase, possess, use, or have under your control any kind of a controlled substance, drug of abuse, CBD oil, kratom, or any variant or analog of any of those that has effects similar to a controlled substance or drug of abuse. Nor can you have any device or instrument that may be used to prepare them for administration or to administer them unless you have a lawful prescription for both the devices as well as the substance. You're also not permitted to have CBD oil or kratom or anything like that, and you're not permitted to have medical marijuana card while in the drug court docket. You're required to submit to drug testing when and as directed. You may not purchase, possess, or use or have in your control alcoholic beverages or be present where they're sold or being consumed, even if that is otherwise lawful. You're not to associate with any co-defendant in this case, nor any other person that has a criminal record as a member of a gang or other criminal group, or any other person who has in the past or could in the future influence you to commit a criminal offense or to violate these conditions unless you have approval in writing from your probation officer. You may not, after the date of this order, marry or establish cohabitation in a common law marriage type relationship with another without written permission. You're required to report any contact with law enforcement, any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer financial information records so your ability to pay any fees or costs can be reviewed. Now, if you're referred during the program by the treatment team or any of your providers for any value assessment for further treatment or counseling or programming beyond that that's already ordered by the court, you must submit to that, and if they recommend any treatment or counseling or programming, then you're to enroll in and complete that successfully. You'll be required to pay the court costs and make payment arrangements to do that. And you'll be required to successfully complete your treatment program and comply with all conditions that the treatment team recommends. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property or place that's under your control where you're found at any time, and you'll have to sign a written acknowledgement of that with the probation and give it to the probation department. There'll be no fine. There'll be no driving suspension imposed. The court costs are ordered to be paid as a condition, but it's also a sensitive order. If you don't make payments on your court costs, the clerk could collect that through other means, including levying on any kind of property that you have, bank accounts, wages, or any other earnings. And if that doesn't collect it, then the court could order you to do community service and give you credit for each hour you worked and an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, in the event the probation department feels that you're not complying, they will file a written notice that with the court. There will be a hearing, and you'll get a copy of that in advance. You'll be entitled to have an attorney at that hearing. If the outcome of that hearing is that you have failed to comply, then at that time the court could terminate you from the court drug docket and revoke your community control and sentence you to a term of incarceration of 6 to 12 months and fine you $2,500. If you serve that sentence in a penitentiary under the state of Ohio, upon completion of that term, they could, as a part of the sentence, decide that you should be under post-release control supervision, which means you'd be supervised under terms that they set. And if they determine that you had not complied, they could return you to prison to make you serve an additional period of up to half of the prison term that the court imposed for one or more violations. But if you committed a felony, then upon completion of that, or upon that occurring, the judge in that case could sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time is left on that period, whichever is greater. And if that occurred, that would be served consecutively the sentence in the new case. All right. Is there anything further from counsel?
No, Your Honor.
All right. Well, that completes your case, Mr. Stewart. So you're no longer under pretrial supervision, house arrest, or anything like that. You'll need to report down to the probation department as soon as you get done here to let them know that you were admitted into drug court so they can talk to you. You've probably already been in touch with Ms. Sturgill. I know you observed last Friday. And so, yeah, I know you're familiar with it, but you'll need to go down and let them know that it's official now that you're in the program. All right? Thank you.
Thank you.
Recording stopped.
Oops. I'm going to put it back on. I thought it was off.
Recording in progress.
All right, this is case number 23 CR 189, State of Ohio versus James V. Brown Jr. Are you James V. Brown Jr. appearing from the jail? All right. This is a hearing to review the bond. Mr. Brown is in custody pursuant to capious order by the court. His attorney appearing by Zoom is William Armentrout. Assistant Prosecutor King is representing the state. He's actually present in court we've been having other hearings this morning. Mr. Brown was indicted in this case for forgery and theft and has failed to appear. And that was on, I believe, December the 4th. He was taken into custody. And so now the matter before the court regarding bond and rescheduling the case. Mr. King has the alleged victim of the victims of the offenses been notified of the time, place, and purpose of this hearing, the right to be heard?
Yes, Your Honor, the individual monitoring the hearing on the Zoom link is the alleged victim,
All right.
or representative of the alleged victim.
All right. And do they wish to be heard on the matter of bond? All right, on the matter of bond then, we'll address that first.
Thank you, Your Honor. During the pendency of this case, this defendant, by my notes, has failed to appear on 3 separate occasions. He failed to appear on November 21st, failed to appear on November 27th, and once again failed to appear on December 13th. He did appear on December 4th, however, he arrived approximately 45 minutes late on that occasion. This defendant seems to think he can appear when and as he pleases and on his own terms. In order to assure his appearance in future proceedings, the state is requesting that a bond be set at this time. I just would ask that $5,000 be the amount of bond, Your Honor. That's all I have.
All right, Mr. Armentrout, regarding the matter of bond.
I wasn't really able to hear that well what Mr. King
Mr. King's recommending $5,000 and indicated that he's had 3 previous failure to appear in this case, and on the one time he did appear on the 4th, he was 45 minutes late.
I think the court may have had some documentation about medical appointments on the other 2. I don't specifically recall. I've not had a chance to talk to James since he was picked up, I think maybe yesterday or the day before. I'm not sure when he was picked up. I don't, if you can tell by looking at the judge, I mean, I looked at his booking photo and he's yellow. I don't know what his current diagnosis is, and I think the court is aware that he does have serious medical problems. I don't know what kind of documentation he may have at this point in time. We'd ask the court to take that into consideration. We did have one pre-trial. He's been made aware of the plea offer, and he was, I don't think he was given, I don't know if I've given him his discovery or not, John, to be quite honest with you. Actually, I think he does have his discovery, Judge, so I'm not sure that what there is left to do by way of a pre-trial.
Yeah, I don't see your compliance yet.
Yeah, I think I see it in my file, Judge. Looks like I filed that on November 27th.
All right, well, oh, here it is. Yeah, it's in the file. Yeah, all right.
James, do you want to address any current?
All right, Mr. Brown, what's the latest excuse?
I was in the hospital. I didn't know I was going to be. I called Sandy.
No, yeah, you called the day you were supposed to be here, I believe.
Because I didn't know I was going to be in there at all. I had to come out of the hospital to use the phone. I had pneumonia. I didn't know I was going to be there. When I went there, still getting over pneumonia. The insurance wouldn't pay any longer. I was supposed to be at dialysis today, but I think I've already missed it. I was coming from there on Monday when they picked me up. There's really no excuse for it except for the fact that I can't determine when I'm going to be in the hospital. I apologize to the court, but it's trying to survive.
Well, Mr. Brown, I understand you have medical problems, but I think you just are ignoring things because you just figure, well, you know, I can do whatever I want because I got all these problems. You know, you call us and you tell us, you never provide any documentation of any of this. Every time I hear from you, it's a different medical problem. Be quiet, be quiet. You know, you start off, you have, you had cancer, then you had a heart problem, Now you're on dialysis. Now you tell me you had pneumonia. It's the disease of the week. You know, it's just one excuse after another. Now, you may have all these things. And if you do, you need to keep in touch and quit calling the court. You call your attorney. You get the information. You know, you called here one day and said you weren't going to be able to make it because you just got out of the hospital. And you were told, well, you're not due until the next day. That was the day you were supposed to be here. And you didn't show up. You were out of the hospital. I know you were out of the hospital because you told my staff you were out of the hospital. And yet you didn't show up. And you never provide any proof. The only time we ever got any proof was when your brother called and was able to get the hospital to fax things to us. And that was, I don't know if that was this case or the other case, because we had another case against you earlier in the year, the same problem. You know, I'm fed up. I'm totally fed up. Put your hand down. If I want to hear from you, I'll ask you to speak. Now, I'm done with this. I am done with it. Now, you know, if I have to put you in jail and have the sheriff convey you to dialysis, if you really need that, you know, that can be done. I don't want to do that because that's an unnecessary expense to the county. But on the other hand, I'm tired of this case, which has been hanging around now, you know, since October. And we've been, you know, the case is really pretty simple, and it has not been able to move because we have one failure to appear after another, and there's always an excuse. Now, the one good thing about you is, you know, you're not hard to find, you know, because the sheriff knows you by heart because they're always looking for you because you never show up, and when you're supposed to, or if you do, you show up late. Now, I'm tired of it. I'm going to give you one more chance. And I'm telling the sheriff, you know, they better start saving their money because if you don't show up the next time, I'm putting you in jail. You're going to stay in jail. I don't care if it costs $10 million to treat you. I'm done with you. Now, I don't know how to make that any more clear. And so I'm not going to ask you if you understand because if you don't get that, you're never going to get anything I have to say. Now, so one more time, the last time I'm releasing you on OR only. And do you have any more hospital visits scheduled or any procedures other than dialysis scheduled? Other than dialysis, do you have any other hospital events scheduled? And when do you go to dialysis?
Monday, Wednesday, and Friday.
Monday, Wednesday, and Friday. All right. So I'm going to set your trial for I got to get this 423 schedule out of here so I can quit looking at it. I'm going to set your trial for January the 11th at 8 a.m. I'm not going to set any more pretrials. If you're intending to resolve this case with your attorney, you get with your attorney, and you need to stay in touch with him because you keep calling the court instead of your attorney. He's your attorney. You know, you got a problem, you call him. He can tell you what you need to do. He can tell you what you need to provide because you just call in and talk to the staff, and you know, and that's not working anymore. Don't call the court. Call your attorney. All right. If you don't show up, then you better have proof that you were in the hospital that day, because the next time I have you arrested, I'm going to make sure you stay in jail. You understand me? All right. Anything further, counsel?
Only, James, I need a good phone number for you.
740-486-4182.
Okay. What about 876-9652?
It's off right now because I'm today to pay the bill.
All right, I've got your mother's number. So on your other phone number, I need to make sure that your voice mailbox isn't full. Okay. And when as soon as you're released sometime today, you need to contact my office right away. Okay.
Okay.
That's all, Judge.
All right. Thank you. All right, this case number 21 CR 161, State of Ohio versus Samaria Jones, and you're Samaria Jones?
Yes.
All right, Miss Jones was convicted of aggravated trafficking of methamphetamine, a third-degree felony, on February 23, 2022. She was placed on community control. Now, I have received a notification filed on the 5th of December from Probation Officer Balser, who's present on behalf of the Probation Department, alleging that you have violated Rule 1, that on or about July 19 of 2023, you were convicted of disorderly conduct in Vandalia Municipal Court. Rule 15, you have failed to pay the court cost of this action and make payment arrangements as ordered them on January the 10th, and then 23. And then on Rule 18, you have failed to make payments on your restitution. I believe you were ordered to make $100 a month payment. It alleges you have not made payments since May 31, June 30, July 31, September 30, October 31, and November 30. Yeah, that was because we were here in January of this year, and at that time, oh, I'm sorry, it's Ms. Kelly, not Mr. Balser, who's a probation officer. And at that time, I know if you made 3 consecutive payments and your restitution, payment of cost and restitution, the violation would be dismissed. And if not, we were to have a hearing on April the 6th. And you made your payments apparently. And then, the court said if you pay the court cost on June the 8th, appearance was not required. And then I received a notice from Officer Kelly that in May that you were making your payments, so there was no need to attend the hearing. So we're back here now on the same thing. Now, you're entitled to have a hearing on this, Ms. Jones, in which the state, through the prosecutor and probation office, is required to prove that you have failed to comply with these conditions. You have a right to have an attorney to represent you, and if you do not have the funds to hire one, the court will appoint one for you. In the event the court finds that you have failed to comply, I can do one of 3 things. I can continue your community control under the same conditions previously ordered, continue it with additional conditions I think are appropriate, or the third, the most serious, is I can revoke your community control and I can sentence you to prison for between 9 and 36 months and fine you $10,000. Now, do you wish to have an attorney to represent you in this matter?
No.
Okay, now you understand that if you don't have the funds to hire an attorney, the court will appoint one for you. You understand that?
Yes.
And if you don't, and in the event that I find that you, and this is the second time you've been here, if I find that you're guilty of violating the terms of community control, I could sentence you to prison, or put you in jail, or some other something else that I think is appropriate. That prison term, it could be up to 6 months in the county jail as a sanction without revoking you, or if I revoke you, I can give you up to 36 months in prison. You understand that?
Yes, well.
And if you don't have an attorney, you'll have to make your own decisions as to how to address these allegations and how to represent and advocate on your own behalf. You understand that?
Yes, well, can I have an attorney then, please?
Yeah. Do you have the money to hire an attorney?
No, sir.
All right. Well, the bailiff will give you a document then to fill out to handle that. Are you working?
I just started back doing like my home health care job, but it's only like
Started back where?
doing my home health care job. I've been working there for about 5 years. So I only got like 15 hours a week because that's all they gave me. But I just made a payment today of like $400. I got the paper right here.
Okay. Well,
I'm trying.
I'm gonna go ahead and, she needs to fill out an attorney form, disclosure form. So I'll go ahead and, find that you, based upon that, you just still have to fill out the payment or the record, that you are entitled to counsel. Appoint Mr. Wagner to represent you. I'm going to, allow you to be released on your own recognizance only, which is your promise to appear. And if you, fail to appear, then you could be prosecuted for an additional felony, and if convicted, sentenced on that, no matter what happens in this case. You're to report to the probation department. Well, she's here, so you can talk to her about that. And we'll set the matter for a hearing. February the 22nd at 1 o'clock. I'm going to do that to give you time to make your payments, to see if you're doing it in accordance with the requirement. Yes?
You said give me time to make the payment, so that's
Pardon me?
just, you said that's gonna give me time to make the payment, so by February.
Yeah, but you're still going to be here.
Right.
Because
So
I'm going to see if you're making your payments. You got a payment due in January, and it'll be another one in February. So, well, it won't be due by the end of February, till the end of February. But in any event, you know, I'm going to, and I'm going to, you know, see what Miss, you know, as far as what Ms. Kelly has to offer as well. But that hearing will be on January 22nd at 1 o'clock in person. And like I said, if you're found to be in violation, you know, you could end up going to either jail or prison that day. So you need to understand the consequences if, you know, if you don't show up, and if, you know, like I said, if you're making payments, then that's going to be taken into consideration. But we also have to deal with the other issue too. So you can talk to your attorney about that. All right, you have any questions?
No, sir.
All right, give, okay, this is case number 20, CR 238, State of Ohio versus Donna Sue Everhart. You are Donna Sue Everhart?
Yes.
All right. Ms. Everhart's present, representing the probation department, Officer Balser. Ms. Everhart, you were put on community control back on March the 3rd of 2021. And I believe that was for aggravated trafficking of methamphetamine, a third-degree felony. The probation department has filed a notification dated December the 6th stating that you have not paid the, you still owe $4,366.50 on a fine. It says you've been making minimal payments of $25 a month. So you were required to make your payment by within your term of community control, and you have not done that yet, and it's going to expire in March. And so that would be a violation of your community control. So the probation department files these things because I can extend the matter up to 5 years to give you additional time. But payment of $25 a month is about, what is that, $300 a year? Yeah, that is for $5,000, that's almost 17 years. Yeah, we're not going to keep you for 17 years. Number one, I can't. But what will happen here is if you're found to have violated the conditions by not paying this by the end of the term, which is what is going to happen here, then the court will extend it for an additional 2 years. But I'm going to put you on a bigger payment plan that makes you pay more so that you get it paid off. But you are entitled to have a hearing on this matter if you want, in which evidence will have to be presented to show what you have or have not done. You're entitled to have an attorney to represent you in that hearing. And if you don't have the money to hire one, the court will appoint one for you. Now, do you wish to have an attorney to represent you in this matter?
I guess it would depend on what kind of payment we're talking about.
Well, I'm not going to negotiate with you.
Okay.
If you aren't certain, then what you need to do is have an attorney.
Well, then probably yes.
All right. Do you have the money to hire an attorney?
No.
Are you working?
Yes.
Where?
Wilmington Auto Center.
Who?
Wilmington Auto Center.
Okay. Are you working full time?
Yes.
All right. Well, you fill out a financial disclosure form, and the court will appoint counsel for you, and we'll set a hearing. Who was your attorney before in this case?
Catherine Hapner.
Okay. All right, so I'll appoint Ms. Hapner subject to your filling out that form. You'll be released on your OR only, which is your promise to appear. Your term of supervision is told pending this violation, but you're still required to comply until we determine what's going to happen here. We'll set this matter for a hearing on February 22nd. Did I miss? No, did I set your hearing for the 22nd of February?
Yes, sir.
Okay. I thought I had set the wrong date. Thank you. That'll be at 1 p.m. All right. So you need to contact your attorney. You're going to go downstairs and sign your OR bond, and then you're still required to report to Mr. Bolzer and comply. And that'll give you time to see what's going on. What I would suggest you do is to get an income tax refund. You ought to apply that to payment of this because you don't want to go to jail if you've had the ability to pay it. So you're going to get are you going to get an income tax refund?
Probably $200 or so. That's what I got last year.
Whatever it is, $25 a month isn't getting it.
Okay.
And so we're going to have to put you on a plan to get you done. You've only got 2.5 more years, so you can do the math. Whatever you owe, divide it by how much time I can give you, which is about 24 or 5 months. That's going to come up to about $180 a month or something. So you need to figure out a way to start paying it, borrow the money, or have somebody to pay it for you legally, whatever. But that's up to you because you're going to have to get it done. All right. So you're going to step around here and sign your assignment notice, go down and sign your OR bond. You might get Ms. Hapner's number, give her a call. She can make an appointment to see her. Don't want to wait for you to show up a day of court and it'll be the first time you talk to her.
Right.
Don't let that happen. All right. Any questions?
No.
All right. Here you go, Ben. All right. Thank you. have the files, Ben. All right, are you Samuel Holliday appearing there from the jail?
Yes, sir.
All right. We have two cases on Mr. Holliday. He's original case is case number 23 CR 136, and then there's a new indictment 23 CR 226. Mr. Holliday is appearing from the jail by video conference. State's represented by Assistant Prosecuting Attorney King, and Mr. Holliday's attorney, Sarah Barger, is present. Both of them are present in the courtroom. So in case number 136, he was charged with aggravated possession of methamphetamine, and there was a pretrial that was supposed to be held on November 8th and did not occur, and the capias was issued, and so he's before the court on that capias. And then there's been a new indictment returned on December 5th by the grand jury, alleging that Mr. Holliday failed to appear in the other case on November the 8th, and that's a 4th-degree felony. And Ms. Barger, you're aware of that case?
Yes, Your Honor.
All right. Let's see, and I think Mr. Holliday filled out do we have a financial disclosure form? Yeah, I have a new financial disclosure form for that case. Mr. Holliday, is everything on this accurate? I don't can't read it where you're. Oh, is that 112 Taylor Drive, number 6? Is that your address?
Yeah.
Okay. All right. Well, the court then will find that Mr. Holliday is indigent, and appoint Ms. Barger to represent him in the new case as well. All right, Ms. Barger, you wish to waive the reading of the indictment and or plea of not guilty on behalf of your client?
Yes, Your Honor.
All right. State wish to be heard on the matter of bond.
Only was contained in the bond recommendation, Your Honor.
All right, Ms. Barger, and we're talking about bond in both cases.
Unfortunately, Your Honor, I have had no contact with this client. I was not aware that he was picked up until this morning, and I was already on my way into the courthouse when I was made aware that he had been picked up. So unfortunately, I haven't got to talk to him. It appears he is local, understanding he does have a failure to appear, keeping in mind that he is indigent. Any bond we would request it be reasonably set so that he can afford it, so that he can get out.
All right. Well, obviously, given the fact that he's failed to appear in his OR bond, the court's not going to grant an OR bond. I'll order bond in each case to be set in the amount of $2,500 plus own recognizance, and that's your promise to appear, and we'll see what happens if you don't. You could be prosecuted and convicted for additional felony. The court will set a pretrial hearing in both cases for January the 17th at 1 p.m. Final pretrial will be set for February 21st at 1 p.m. And trial date will be set for March 11th at 8 a.m. If you make bond, you're under the same conditions previously ordered, including the house arrest and pretrial supervision as set forth in your original order. All right. Is there anything further from counsel?
No, Your Honor.
All right. Thank you, officer.
Thank you.
All right, this is case number 23 CR 198, State of Ohio versus Melanie Anderson, representing the states. Assistant Prosecutor King, representing the defendants, Attorney Sarah Barker. And are you Melanie Anderson?
Yes, sir.
All right, Ms. Anderson is charged, along with 6 other individuals, in a multi-count indictment. I believe she is charged in counts 27, 28, and 29. The court was notified that parties had reached an agreement, and the matter was set for a plea hearing at the request of counsel. And I have been presented, Ms. Anderson, with a plea of guilty form for the prosecutor's diversion program and a waiver of speedy trial time to allow screening for diversion, as well as a judgment entry to admit into the diversion program. Now, this looks like it's proposed that you're going to plead guilty to counts 27 and 28 under 2925.13b, revised code, both 5th degree felonies. This document is 3 pages long. On page 3, there is a sentence halfway down the page, actually the last sentence on the page, that reads, "I enter this plea voluntarily," and below that appears to be the signature Melanie Anderson. And is this your signature I'm looking at on this document?
Yes, sir.
When did you sign it?
Just a few minutes ago.
All right. When you signed this, did you understand that was an agreement to plead guilty to go into the diversion program, meaning there's not going to be a trial?
Yes, sir.
Okay. And is this something you and your attorney have been talking about before today?
Yes, sir.
So when you came here today and were presented with this document, you were not surprised? This is what you expected?
Yes, sir.
And have you had enough time to fully consider the matter before making the decision?
Yes, sir.
And did you enter into this agreement voluntarily?
Yes, sir.
Now, I know your attorney's gone over this with you, but under the law, I'm required to explain it to you. Normally, if a person pleads guilty to a charge, then there is a sentence imposed, which in this case could be 6 to 12 months incarceration on each count, could be a fine of $2,500. It could be a license suspension of 6 months to 5 years. And then once the court imposes that sentence, or it could be community control or probation for up to 5 years. Once the court imposes a penalty or a sentence, then that person has a conviction, and it's reported, it's in the public records, and it's listed as a conviction. Now, there's a provision in the law that provides that if the prosecutor's office deems you to be an appropriate person to be in the program, they can put you into their diversion program. Now, that's a program that has been approved by the court and filed. There's an entry that approves that. It sets forth the conditions. You sign an agreement with the prosecutor's office to do certain things, and then you are supervised as a condition of that for a period of time as determined by the prosecutor, by the probation department, under conditions that are not as extensive or as strict as if there was a conviction. Now, what you do is if you plead guilty, the court doesn't find you guilty. Instead, I admit you into the diversion program, and then I wait for the report from the probation department and the prosecutor's office as to your compliance with that program. And you have to comply with the agreements that you've entered into with the state. So it's a contract of sorts, more or less, for all practical purposes. Now, even though you plead guilty and I place you into the diversion program, I do not make a finding of guilty, and there is no sentence imposed. And so under the law, until you've actually been sentenced, you are not considered to have a felony conviction. And so even though it'll be, if someone looks in the record and says that there was a plea of guilty entered, that doesn't mean you're a convicted felon. It means that you are in a diversion program and the case is still open. It'll be inactive, but it's open. And so if you're asked if you have a felony conviction, you can honestly say, no, I do not. And then you can show them the entry that puts you into the diversion program. If you complete the contract successfully, then the prosecutor notifies the court at the time that you completed the agreement that they're satisfied, and at that time, the court dismisses the charge. even though you pled guilty. And then I schedule it for a hearing to seal the record. And assuming that nothing happens between the date that is filed, other new charges or something, or some other condition that would warrant you not being eligible, the court then seals the record. And that means that all references are taken out of the public records, it's taken off the computer records and so forth, and you do not have a conviction. Now, if somebody were aware of your charge and the fact you pled guilty and says, well, I know that you had that charge, then you'll have a copy of the entry that shows it was dismissed and that your record was sealed. So that's the benefit to you. Now, the detriment to you, or the downside, is that if you plead guilty and you fail to comply with the program, the prosecutor's office has pretty much, total discretion on whether or not you're compliant. And if they say you're not, then they notify the court and you come back, and at that time, then I would impose a sentence. And so that's what the downside is. You don't get a chance to try this. If it doesn't work out, come back and say, okay, let's have a trial. And so that's why we go through this at this time. And now, if that happens, they notify the court brings you back, we put the case back on the active docket, and then we set a sentencing hearing. Now, at that time, then the court would impose a sentence. It could be, like I said, a term of incarceration, could be a fine, could be a license suspension, could be community control for up to 5 years, or any combination of that. If that were to happen, if you were to get community control, then that would be supervision for 5 years under more strict terms and more extensive terms. And if during a period of time it was alleged that you had failed to comply, in that case there would be a notification by the probation department with a copy given to you, be in writing, and there would be a hearing, and you'd be entitled to have an attorney. And if the outcome of that hearing was that you had failed to comply, then at that time the court could then impose the term of incarceration of 6 to 24 months, 6 to 12 on each, or 12 months total on each as a possible sentence. So that means the maximum is 24 months. There could be a maximum fine at that time of $5,000 and a license suspension on each of 6 months to 5 years. Now, do you understand all that?
Yes, sir.
Okay. In the event that you should ever be sentenced to a term of incarceration for these offenses, if you plead guilty and if you are found to have violated and go to prison, then upon completion of that term, the law provides the Adult Parole Authority could put you under post-release control for a period of up to 2 years under the terms they set, and if during that period of time they determine you've not complied, then they could they could return you to prison, make you serve an additional period of up to 9 months for a single violation, but there's a cap or limit of half of whatever the prison term that was that you were required to serve for all violations. But if there's a new felony conviction, then in addition to whatever sentence the judge in a new case imposes upon you, that judge is also authorized to sentence you for committing that offense or under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in the new case. You understand that?
Yes, sir.
All right. Now, the charges in the 27th count and 28th count, I'll just read the first one, count 27, because I assume they're identical, separate date. Actually, they're the same. Both read that on or about the period of January 1, 2021, continuing through December 31, 2021, in Highland County, Ohio, you being the owner, lessee, occupant, or person who has custody, control, or supervision of the premises, real estate, including vacant land located at 220 Southeast Street, Hillsborough, knowingly permitted the premises to be used for the commission of a felony drug offense, to wit, trafficking of marijuana in violation of section 2925.03A1 and 2925.03A2 by another person, to wit, Justin Kyle Anderson. And that would be in violation of section 2925.13B. And then count 28 alleges the same thing and the same address. I assume those are two separate incidences alleged.
It's two separate time frames, Your Honor.
Oh, yeah, okay, I'm sorry. Yeah, count 1 is January 2021 to December 31, 21, and then 28 is same months, but for 2022. Okay. Thank you. Now, do you understand what it is the state alleges you did in those 2 counts, what they said you did, when, where, and how they alleged you did it?
Yes, sir.
And you understand the possible penalty?
Yes, sir.
Have you discussed the nature of the charges, the evidence in the case, possible legal issues in the case, and possible defenses you might try to raise at trial, and possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with her advice and competence in this matter?
Yes, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir.
Now, other than, well, let me read the language on page 2 that's printed in bold and underlined. And that reads as follows. Defendant shall enter a plea of guilty to count 27 and count 28. State will dismiss count 29. Prosecuting attorney recommends defendant be placed in Hyden County Prosecuting Attorney's Diversion Program. Defendant agrees to pay restitution the amount of $5,000 be distributed equally between the Hyden County Task Force, Hyden County Sheriff's Office, and Hillsborough Police Department. And defendant agrees to cooperate fully with the state, including testifying against co-defendants. Now, is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty?
No, sir.
Regarding the language in the plea, I think that would have to say the task or the was it law enforcement trust fund for each, or is that the language now today?
Okay, I believe
I mean,
that would be correct. And
all right.
distributed equally between the 3
All right.
agencies.
So make sure you put that into the agreement. And by the way, there has been a diversion agreement signed already?
Yes, sir.
And has she paid the fee for
Yes,
that?
Your Honor.
Okay. All right. All right, now, because this is your last chance to stand on a not guilty plea to have a trial, and it's proposed you plead guilty, you have to understand the constitutional rights you have before I can accept that plea. Now, first of all, you have a right to have an attorney, and Ms. Barger, you've employed her. Now, in the event that you did not have the funds to continue to pay counsel to represent you, court would appoint an attorney for you at no cost. So the reason I bring that up is you're not entering into this agreement today because of your concern about ability to pay for legal defense.
No.
Okay. Now, under the Constitution and the laws of this state, you have a right to have a jury trial in this matter in which 12 people be selected from a group of citizens that live in Highland County that, excuse me, that are summoned for jury duty on your trial date. After those persons are selected, the evidence will be presented, they will be instructed on the law, and then that jury would decide by unanimous verdict, meaning all 12 would have to agree on each case and each count as to whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you did want to plead guilty, you can waive, which means to give up in writing, the right to have a jury trial. And in that case, you would have what's called a court or bench trial, meaning the judge would be the one who would hear the evidence instead of a jury. The judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, Ms. Anderson, you have a right to confront witnesses against you and to cross-examine them in open court through your attorney. What that means, the witnesses against you would have to come into the courtroom and testify in public. Excuse me. Still having sinus issues. They would have to testify in public in front of you, your attorney, and anyone else is present. After the prosecutor was done asking questions, your attorney would ask questions, ask cross-examination. The purpose of that is to try to bring out evidence that helps your side of the case. You understand that?
Yes.
Now, under the Constitution, you have the right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So what that means is that if you have witnesses you're not certain are going to come in voluntarily, then upon your request, the court issues a court order that's a subpoena, and that forces people that are named in the subpoena to come to court to be available to testify on your behalf at trial if you want them to, even though they don't want to be involved or be here, which is the same way the state's witnesses are forced to come to testify against you at trial. You understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence at any time in this matter, including trial. No one can ever make you testify at trial or at any other point in the case. Prosecutor can, the judge can, it's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you do not testify, the judge does instruct the jury that because it is your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Under the Constitution, Ms. Anderson, you're presumed innocent of this offense until or both offenses until proven guilty by the state of Ohio, every essential element of the offense is charged. What that means is that the burden of proof is on you to try to prove you're not guilty of these offenses simply because you've been accused by being indicted. In fact, under the law, you're not required to present any evidence in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt on each offense by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. And again, that verdict would have to be unanimous. All 12 jurors would have to agree in each count. Do you understand that?
Yes, sir.
Now, you originally pled not guilty. Plea of not guilty denies allegation in the indictment in those 2 counts against you, denies you committed any crime, and it exercises or invokes all the rights I just mentioned. If you change your plea from not guilty to guilty as to these 2 counts, that is the opposite of not guilty plea. The guilty plea admits the allegations in each count of the indictment that you're pleading guilty to, counts 27 and 28, admits that they're a crime, that you committed that crime. And that plea waives, gives up all the rights I've just described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what you're pleading. Well, that exception, your plea of guilty, would waive or give up the right to a jury or court trial, waive or give up the right to confront witnesses against you and to cross-examine them through your attorney in open court, waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It would waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty if there's a future guilty finding. There wouldn't be initially, but at least that would be, wouldn't be used if eventually that happened. And it waives, gives up your right to require the state to prove your guilt by proof beyond reasonable doubt on each element of the offense that's charged, because if you plead guilty, that's what's used to find you guilty. And they don't have to prove it. Finally, it would waive or give up any right to file an appeal on any alleged violations of your rights you feel could have occurred up until this point in the case. Now, in the future, should you be revoked and sentenced on this case, you can file an appeal, and if that were the maximum sentence, you could file an appeal. Any appeal that you would file would have to be filed within 30 days of your sentencing entry being filed. Now, do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
And did you enter into this agreement voluntarily here today?
Yes, sir.
And you don't feel you were pressured or rushed in any way into it?
No.
Okay. Now, do you have any questions about the diversion process, or what's involved, or what will be required of you?
No, sir.
Do you understand?
Yes, sir.
Do you have any questions about the charges or the possible penalties for the charges should you be convicted?
No, sir.
Do you understand those?
Yes, sir.
Do you understand the constitutional rights I've explained?
Yes, sir.
And do you understand the plea of guilty, what it means, what will happen if you enter that plea here today?
Yes, sir.
Is there anything you would like to speak to your attorney about before we go any further?
No, sir.
All right, then, is it your decision to withdraw your non-guilty plea to counts 27 and 28 and enter pleas of guilty in accordance with the paperwork and the agreement that I've, a plea of guilty form that I've just gone over?
Yes, sir.
Okay, then as to count 27, which alleges on about the period of January 1, 2021, continuing through December 31, 2021, in Highland County, Ohio, that you being the owner, lessee, occupant, or person who has custody, control, or supervision of the premises real estate, including vacant land, located at 220 South East Street, Hillsborough, knowingly permitted the premises to be used for the commission of a felony drug offense, to wit, trafficking in marijuana in violation of section 2925.03A1 and 2925.03A2 by another person, to wit, Justin Kyle Anderson, in violation of section 2925.13B of the Higher Revised Code, charge of permitting drug abuse, a 5th-degree felony carrying a possible prison term of between 6 and 12 months, fine of $2,500, and a license suspension of 6 months to 5 years. How do you plead?
Guilty.
Okay, there isn't a license suspension on this one, that's right. I forgot. But otherwise, the penalties I described are applicable. And how do you plead to that?
Guilty.
All right, and then it's count 28, which alleges the same language and is the same offense, except that it alleges that that occurred between January 1, 2022 and continued through December 31, 2022. But otherwise, the same language and the same offense. How do you plead?
Guilty.
All right, thank you. You can be seated. All right, and I did not ask earlier, but I believe you did sign I mentioned it, but I didn't ask you if you signed it, but there's a waiver of the speedy trial time for purposes of the completion of this, and you signed that as well?
Yes, sir.
All right, thank you. All right, the court will find that on this day at open court, the defendant was advised of all of her constitutional rights, made a no intelligent voluntary waiver of the same pursuant to criminal rule 11. Pleas are accepted and ordered filed and will be noted in the file. Now the court further finds that the defendant has been accepted and has signed a diversion agreement with the prosecuting attorney's office and has requested to be admitted into that program. And so, pursuant to the written standards of that program that have been approved by the court will accept the guilty plea, but will not make a finding on either count at this time, but instead will hold those pleas in abeyance pending the report from the prosecutor's office about the defendant's progress in the diversion program. So there will be no finding of guilt on either count. The defendant is to pay the court cost in accordance with the terms of the agreement, and the restitution agreed. I'm going to add that to the language of the entry. It's not in our standard form. And that's payable to, we'll put in here, LET, Law Enforcement Trust Funds of payees.
Can that be paid through victim witness, Your Honor, and the victim witness can distribute it, like we do restitution in task force cases?
Yeah, payable through the victim witness, and there'll be a service fee charged for that. Just add that to your agreement.
Yes, sir.
All right. No. Court finds the defendant has paid the participation fee and will be required to pay any further fees that might be required as set forth in that agreement, if there are any. And the arresting officer or investigating officers are notified of this disposition and an agreement?
Yes, Your Honor.
All right. All right. And then count 29 is not dismissed yet because she has to complete the agreement, but when you file the notification, make sure you note that 29 is going to be terminated or dismissed as well. Right. No, actually, I guess it is dismissed now because, because she's pleaded guilty. So, yeah. Count 20, that's count 29, right, the forfeiture?
Yes, Your Honor.
Count 29 is dismissed. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, Ms. Anderson, this completes your case. You're no longer under pretrial supervision, so none of those conditions apply, house arrest or reporting or anything of that nature. You will be required to report in accordance with the terms of the conditions of this program. So as soon as you get done here, you need to report to probation, let them know you've been put in diversion program, and then they'll have an officer do a intake with you and go over that with you and give you all the paperwork and everything so you know what you're required to do. And from today forward, you'll be required to comply with those conditions. All right, thank you. All right, you Melissa Willis. Right. Okay, case number 22 CR 82, State of Ohio versus Melissa J. Willis. Appearing on behalf of the state is Assistant Prosecuting Attorney King. Appearing on behalf of the defendant is Attorney Catherine Hapner, and you're Melissa J. Willis.
Yes, Your Honor.
All right, Ms. Willis was convicted of endangering children, a first-degree misdemeanor, on June 27th, 2022, and was placed on 18 months of community control. There was a notification filed on November 29th that the defendant had failed to comply with the conditions of that order, specifically Rule 1, that on about September 26, 2022, she was convicted in Highland County Court of endangering children. Rule 2, failed to report to the probation department as ordered on October 5th. Rule 15 had failed to pay $194 in court costs as ordered and has not made any payments. And Rule 19 had failed to complete and or provide documentation of completion of parenting class on or after 11/3. Now that was filed with the court on the 29th. The court notified Ms. Willis of the allegation, and Ms. Hapner was appointed to represent her, and we're now before the court on the matter of hearing. All right, Ms. Hapner, have you had a chance to review those allegations with your client?
I have.
All right, does she wish to have a hearing on this matter?
Well, I have also spoken with the probation department, and if we could take a 5-minute recess, we may be able to resolve the
Okay.
issues.
All right, that'll be fine. All right, we're back on the record. And council took a break. Just want to make a report to the court, please.
Yes, Your Honor. The parties would ask the court just to continue this hearing for approximately 1 to 2 months to give the parties time to confirm that the defendant has actually paid her court costs and complied with the other conditions.
All right. You're in agreement with that, Ms. Hammond?
I am, yes.
All right, well, we'll continue this matter until February the 22nd at 1 o'clock. Any event that the costs are paid, I assume that's going to mean a dismissal?
Yes, sir, Your Honor.
All right, and if that's the case, then just get that filed. And if it's dismissed, then you will not have to appear. If we don't have a dismissal entry and your attorney doesn't tell you don't come, then come. But assuming you've paid the cost and they confirm it, that sounds like you won't need to be here.
Yes,
All
Your
right?
Honor.
But just again, just confirm to your attorney. All right, thank you.
Thank you.
You guys.
All right. This is case number 23 CR 202, State of Ohio versus Derek Blane. This is a pretrial being conducted by Zoom. Mr. Lane is represented by Dennis Kirk, who's appearing from his office, and representing the state is Assistant Prosecutor Adam King, appearing from his office. Defendant is charged with grand theft, receiving, and forgery. I believe this is a first pretrial. Final pretrial set for December 20, and we have a trial date of January 8. See that bill particulars and discovery was provided to the defense, and you received that, Mr. Kirk. Was dated filed on the 18th?
I did, Your Honor.
Okay. And your discovery will be due then by the final pretrial. Do you anticipate any? Pardon me?
I filed it this morning.
Oh, okay.
And Your Honor, this actually is the final pretrial.
Oh, is it? Oh, that's right, it is. Yeah, I forgot where we're at this. All right, so the trial's set for the 8th. Okay. All right, so there's no pretrial motions, is that correct?
That's correct. The only thing that we would be considering, and I don't know if the court needs a written motion or an oral motion would be sufficient, is this is set for trial. I was just appointed to receive the entry last week, appointing me, so it's a pretty quick turnaround time because of the speedy trial. Spoke with my client about waiving speedy trial so we can get a little bit of time to speak with the state further. And the Alan Shoemaker trial is set for the 8th right now, January, when this case is set. So would contemplate a motion to continue the trial.
Is your client willing to waive time on that?
He reported to me he is, and I went over that with him. I didn't have a written form with me, but I explained it to him, and he indicated he would waive it upon the record.
All right. Is that correct, Mr. Lane? You're in agreement with that, to give your attorney some more time?
Yes, sir.
All right. Go ahead.
Just wanted to put on the record, the state doesn't have an objection, but I also have not had a chance to consult with the victim.
Oh, that's right, I forgot. So has the victim been notified of this pretrial?
They've been notified of this pretrial, Your Honor. They'd like not to appear, and I haven't had a chance to discuss the possible continuance with them.
Okay. Well, given the fact that this case was indicted on December the 5th, it is I said it because of the speedy trial issue. I think I even mentioned it to Mr. Lane at the time that it would be subject to being extended if he and his attorney needed more time. So I'm going to go ahead and grant it because we need to be able to know what the docket is, and we're running out of time here, and I'll be gone the week after Christmas. So I'm going to go ahead and grant the motion to continue. Currently scheduled for January the 8th. And I'm going to put in there that the defendant waived the speedy trial time on the record. And so about January 25th, Mr. Kirk.
I believe we can make that work, yes.
All right. So we'll continue it to January the 25th at 8 a.m. And as far as, I'm not going to schedule any other pretrials, but if there's a need for anything further from the court, just contact the assignment commissioner and we'll set it for hearing.
Okay.
All right. Anything else then to discuss at this time?
No, Your Honor.
No, Your Honor.
All right. Thank you, Mr. Lane. All right, Travis Zuber then. All right, this is case number 23 CR 193, State of Ohio versus Travis James Zuber. This is a pretrial being conducted by Zoom, and you are Travis Zuber, appearing on the screen marked Travis Zuber.
Yes, sir.
All right. All right. And Mr. Zuber's attorney is Justin Mullen, appearing from his office. Appearing from the prosecutor's office, Assistant Prosecutor King. Defendant charged with engaging in a pattern of corrupt activity. And looks like trafficking and possession of hashish and a forfeiture. I believe this is a first pretrial. All right. Yeah, here we go. And a final pretrial set for the 3rd. And we had the jury trial set for the 8th because at the time I arraigned Mr. Zuber, I believe he was in custody, but he is now out on bond. When did you obtain bond, Mr. Zuber?
I believe it was November 16th.
All right. Okay, the day of the arraignment. Okay. All right. So that obviates the need for that, and so we can talk about that here in a moment. Now, let's see. I'm looking here at what's been filed. Looks like the state provided bill of particulars on the 14th, as well as discovery. And have you provided your discovery yet, Mr. McMullen?
Nothing yet, Your Honor.
All right. Has there been you anticipate any pretrial motions?
No pretrial motions, Your Honor. The state and I have engaged in extensive plea negotiations, which I believe will result in a deal in this case, Your Honor.
Okay. All right. Well, given that we have a trial on the 8th, which I'm fairly certain is going to be going, and that individual is in custody, I want to go ahead and let's get a backup, a trial date that will move this back to, just to be safe. When are the co-defendants set for trial, Mr. King?
I believe Mr. Anderson was only in March.
Okay.
Several of the other co-defendants have already pled, and one of them has not been picked up yet.
All right, so is Mr. Anderson the only other trial date we have at the moment?
Mr. Anderson has a trial date, and Mr. Fetra will also have a trial date.
All right. These are cases, though, probably have to be tried together or separately, I would think. Or do you know?
I believe they can be tried together.
Think it could be? All right.
Right now, yes.
Okay, what is Anderson's trial date? March what?
Hang on, I'm trying to figure out my calendar, Your Honor. 1 second. Mr. Anderson's set for March 6th. Well, no, that's his final pretrial. Jury trial March 25th.
Well, I don't want to. I hate to have two co-defendants going out there at the same time. If you feel that it's possible to try both, there's not a brutal problem.
No, there would not be. It would be possible.
All right. All right. Well, then, what's your schedule look like on March the 26th, Mr. McMullen?
I'm available.
All right.
Monday the 25th, Your Honor.
I'm sorry?
Monday, March 25th is when Mr. Anderson's trial is set.
25th. Okay.
Correct.
All right. All right. We'll set a final pretrial then. The trial will be continued on the court's motion, and courts are going to charge that time to speedy trial under 2945-72H due to the court's schedule, and the defendant's now free on bond. And we'll set that pretrial for February the 14th at 1 o'clock. Okay, and in the meantime, Mr. Mullen, if you think that there may be a resolution, I'd prefer to have it done, you know, before the pretrial, but, you know, you guys keep working and keep the court informed if you need to have a hearing date before that.
Absolutely will, thank you.
All right, anything further then from the council?
No, Your Honor.
All right,
No, Your Honor.
all right, thank you.
Thank you. Thank you.
Let's see. All right, this is case number 23, CR 217, State of Ohio versus Joshua Aaron Kern. This is a pretrial being conducted by Zoom. Are you Joshua Aaron Kern, appearing from the probation department?
Yes.
All right. Mr. Kern's attorney is Thomas Kidd, appearing from his office, appearing from the prosecutor's office, Assistant Prosecutor King. Defense charged with abduction, strangulation, and domestic violence. Mr. King, has the alleged victim of the indictment been notified of the time, place, and purpose of this hearing, the right to be heard?
Yes, Your Honor, she's monitoring this hearing on the screen marked by the county victim witness.
All right. The first pretrial, final pretrial set for January 17, and we have a trial date set on February 12. Now, let's see. I see that there's been some, okay, looks like the state filed compliance with discovery and request for discovery on the 14th, and you received that, Mr. Kidd?
I have, Your Honor.
All right. Was there a bill of particulars as well requested?
There was, and indeed provided, much appreciated.
All right. Well, you'll be required to file a response to the state's request by the final pretrial. I note that you put in your demand that you didn't have anything, but once the state files a demand, the court takes position that supplements due, just as an ordinary course of Rule 16. So that'll be due by the final pretrial. Do you anticipate any pretrial motions?
I do not, Your Honor.
Okay. Well, if you should find that there are any to be filed, they need to be filed by the final pretrial as well.
Discovery does not appear there any
Okay.
for my client.
All right. Has there been a written plea offer provided yet?
Yes, Your Honor.
All right. Is your client aware of that, Mr. Kidd?
He is, Your Honor. We have started to discuss that. I have been in some conversations with the prosecutor's office regarding that as well.
All right. All right. Are there any other matters then that need to be discussed at this time?
No, Your Honor.
Not on behalf of Mr. Kern either.
All right. Then the final pretrial will be the 17th of January, and that could be by Zoom. We'll make that decision a little closer to the time. All right. Thank you very much.
Thank you, Your Honor.